Welcome to my channel, USA Immigration and Visa, your ultimate guide to navigating the complexities of U.S. immigration and visas. Join us for U.S. immigration information, practical tips to help you achieve your immigration goals. Join us today as we explore options if you're H1B not selected. Discover alternative pathways and strategies to navigate through this challenging situation. Let's start the video. To check if USCIS picked your registration, log in to the MyUSCIS portal and look for the word "Selected" beside your registration. If you didn't get selected, don't worry. There are other ways to get an H-1B visa and work legally in the U.S. Talk to your immigration lawyer about these options so you can maximize your chances of getting approved with the right criteria. Second chance lottery this summer. There might be another chance, late summer, for those who didn't get picked in the first lottery. This is because some of the selected registrations might not file a full H-1B application by June 30th, 2022. So their lottery spots will go to the ones who were on the waitlist. If you were one of them, don't give up hope. You might get lucky in the second lottery in July. But the odds are low because there were too many applications this year. You don't have to do anything else to be in the second lottery. It will happen automatically. O-1A visa. Individuals with extraordinary ability or achievement. The O-1A visa is a non-immigrant visa designed for those who possess extraordinary ability or achievement in the following fields: science, arts, education, business, or athletics. Under the broader O-1B, there are other classifications for those who have proven extraordinary achievement in the motion picture or television industry. The petitioning U.S. employer would need to provide evidence to prove that the employee meets the O-1 visa criteria. O-1A versus H-1B visa. If you are a top professional in your field, the O-1A visa might be a better option than the H-1B visa. Why? First, the O-1A visa has no cap, so you don't have to worry about the government's quota. Second, the O-1A visa lasts for 3 years, but you can renew it every year, and there is no limit to how many times you can do that. To get the O-1A visa, you need to show that you have sustained national or international acclaim. Another advantage is that you can bring your key staff with you to the U.S. under the O-2 visa. For example, if you're a famous scientist, you can bring your lab assistant, as long as they meet the requirements. O-1 versus P-1 visas. The O-1 and P-1 visas are for people with extraordinary skills in the arts, sciences, business, education, sports, and entertainment. To get the P-1 visa, you need to be famous internationally. If you want the P-1 visa as an athlete, you need to show 2 of these things. 1. You played in U.S. sports leagues before. 2. You played in an international match with your national team. 3. You have a letter from a media or industry expert, but the P-1 visa has some drawbacks. Your family members can't work in the U.S. unless they get a work visa. And if you are an entertainer, you can't perform solo. You can only stay in the U.S. for 5 years with the P-1 visa, and you can extend it, but not more than 10 years in total. L-1 visa for temporary workers. If your company has offices in the U.S. and wants to move some employees there for a while, the L-1A or L-1B visas are good options. To get an L-1A visa, your employer needs to show that you have been working for the foreign office/branch or subsidiary for at least 1 year in the past 3 years as a manager, executive, or expert employee. L-1 visa versus H-1B visa. In this video, we're diving into 2 of the most sought-after work visas in the United States, the H-1B visa and the L-1 visa. Within the L-1 category, there are 2 distinct paths, the L-1A for managers and executives, and the L-1B for those with specialized knowledge. While both serve as alternatives to the H-1B visa, there are crucial differences to note. The L-1 visa is tailored for employees already working in a foreign branch of a U.S.-based company or those planning to conduct business on behalf of a foreign employer within the United States. On the other hand, the H-1B visa is for professionals working directly for a U.S.-based company, requiring sponsorship from that employer. One key divergence lies in wage requirements. Unlike the H-1B, the L-1 H1 visa does not mandate payment of the prevailing wage for the intended work area. This aspect, along with considerations such as spousal employment authorization, can heavily influence your decision between the two visas. Additionally, the process of acquiring either visa can vary based on factors like the availability of qualified workers in the U.S., office locations for L1 applicants, and the unpredictability of the H1B lottery. Consulting with an immigration lawyer is crucial to navigating these complexities effectively. So whether you're considering a career move to the States or seeking the best visa option for your employees, understanding the nuances between the H1B and L1 visas is essential. H2B visa for temporary non-agricultural workers. In our video today, we're exploring the H2B program, which serves as a pathway for U.S. employers to hire temporary non-agricultural workers. This program caters to a wide range of industries and job types, from skilled to unskilled labor, encompassing roles such as entertainers, camp counselors, home attendants for terminally ill patients, ski instructors, and business trainers. To qualify for the H2B visa, employers must demonstrate several key factors. First, that there's a genuine shortage of qualified U.S. workers available for the job. Second, that hiring a temporary H2B worker won't adversely impact the wages or working conditions of American employees in similar roles. And third, that the position is genuinely temporary, whether due to seasonal demands, a one-time event, or peak workload periods. Navigating the full scope of H2B requirements is essential for both employers and potential visa applicants. It's worth noting that there's an annual numerical cap of 66,000 visas, with 33,000 allocated for workers beginning employment in the first half of the fiscal year, and any remaining slots carried over to the second half. Understanding these intricacies is crucial for anyone considering or involved in the H2B visa process. So, let's delve into the details together to grasp the opportunities and challenges presented by this program. H2B visa versus H1B visa. The H2B visa and H1B visa are different in the kinds of jobs they cover and how long they last. The H2B visa is for 3 years, but the H1B visa is for 6 years. The H1B visa also lets you stay and work in the U.S. permanently with a green card. You just need a U.S. employer who can sponsor your green card by filing some forms for you. The H2B visa does not let you do that, so you have to go back when it ends. TN visa for Canadian and Mexican professionals. The TN visa is for Canadian and Mexican professionals who want to work in the U.S. for a short time. It was made under the NAFTA deal to boost business and trade among the 3 countries. The visa lets these people work in the U.S. in a job that NAFTA allows. TN visa versus H1B visa. The TN visa has some advantages over the H1B visa. With the TN visa, you can stay for 3 years and renew it as many times as you want. With the H1B visa, you can only renew it once, and after 6 years, you have to go back to your country for a year unless you can get the time back or you have applied for a green card. If you apply for a green card, you can stay longer than 6 years without going back. The TN visa lets you stay longer and easier than the H1B visa. F1 Optional Practical Training Extension. If you are an F1 student and you applied for the H1B visa, you can stay and work in the U.S. for 24 more months with the OPT STEM extension. To get it, you need to have a STEM degree. Your employer also needs to be e-verified, and you need to apply for the extension before your OPT ends. If your OPT ends before your H1B starts on October 1st, read this post about the OPT cap gap rule. It lets you keep your status if your H1B is pending or approved and selected. E3 visa. Specialty occupation workers from Australia. The E3 visa is for Australians and their families who want to work in the U.S. in a special job, the same kind of job as the H1B visa. The family members don't have to be from Australia. To get an E3 visa, you need to 1. Be an Australian citizen. 2. Have a real job offer in the U.S. 3. Have the right education or skills, work in a special job. E3 visa versus H1B visa. The E3 visa is a special option for Australians who want to work in the U.S. Unlike the H1B visa, The E3 visa has no lottery and less competition. You can also keep renewing it as long as you want, just like the TN visa. Another advantage of the E3 visa is that you save money on some fees that the H1B visa requires, such as the ACWA and fraud prevention fees. To get the E3 visa, you can apply directly at the U.S. consulate in Australia without filing an I-129 form first. J1 visa, Exchange Visitor Program. The J1 visa is a type of visa for foreigners who come to the U.S. as exchange visitors. They join a program approved by the Department of State to do different activities, such as teaching, studying, training, or showing their skills. Some examples of people who can get a J1 visa are business trainees, school teachers, college professors, research scholars, medical residents, or interns who are learning medicine in the U.S. and other experts. J1 visa versus H1B visa. The J1 visa and the H1B visa have some big differences. One of them is that the J1 visa may make you go back to your home country for 2 years after your exchange program. This is a U.S. law in the Immigration and Nationality Act, Section 212E. If you don't want to go back, you need to get a waiver. The Department of Homeland Security has to approve your waiver before you can change your visa status or get a new visa in the U.S. Another difference is that the J1 visa lasts for up to 3 years, while the H1B visa lasts for up to 6 years. With the H1B visa, you can only work for the employer who sponsored you for the specific job. With the J1 visa, you can get paid by the school/institution that gave you the DS 2019 form, and you can also do some extra work, with permission, if it is related to your program. Your spouse or children can come with you to the U.S. on a J2 visa, and they can also work with an Employment Authorization Document, EAD. But their income cannot be the main source of support for the J1 visa holder. Permanent residency. Some foreign workers can skip the H1B process and go straight for an employment-based green card. This can be a better option if you are not from China or India and you have a bachelor's or master's degree and 5 years of experience. Right now, the visa wait times are over 4 years for people from these 2 countries. As we conclude, remember that while the H1B lottery may present hurdles, it's not the end of your American dream. Stay resilient, explore your options, and consider seeking professional guidance to tailor a strategy that aligns with your goals. Keep believing in your abilities and never lose sight of your determination to succeed. Thank you for watching, and don't forget to subscribe for more valuable insights on USA immigration and visa. Until next time, best of luck on your immigration journey.